Welcome everybody. My name is Paul Holden. I'm the President and CEO of the Burnaby Board of Trade, and welcome to the latest in what's becoming an increasingly long line of Zoom events that we're putting out there. Obviously, because of the current circumstances, it's a little more difficult to do some in-person events. Although we have done one a couple of weeks ago, and we're looking to develop some more of those. But certainly in terms of the number of interactions we're having with our members and with the business community through events such as these, we've never done as many. So it's one advantage of the Zoom world is being able to present some really valuable information to our members and to the business community on a more regular basis. So for those of you that are maybe less familiar with us as an organisation, just a couple of words on that. The Burnaby Board of Trade is the Chamber of Commerce for the City of Burnaby and also the Economic Development Office for Burnaby. We have around 1,100 members, anything from small individual, maybe even one-person operations, right the way through to some of the larger corporations that you'll see dotted around the City of Burnaby, such as TELUS, Electronic Arts, Pacific Blue Cross, and many, many more. It's our role, essentially, to support business. It's our role to be a catalyst for economic development, to be a convener of business and community leaders, and to be a champion for business. You'll have all probably seen some of the results of the advocacy work we've been doing on behalf of business ever since really the impacts of COVID became clear in early to mid-March. So now, of course, we've moved on a little bit in terms of from the early days of everything shutting down, and obviously we had several months of that, and now we're in a stage where we're looking we're in various stages of restarting operations. For us, we started to bring people back at the end of May when that phase was opened up through the provincial medical office, and I know many other businesses are looking now at what they can do to bring their staff back, especially as schools start to open again after Labor Day. So I'm really excited today to have our friends from Forte Law joining us to give us some insights as to what employers can and I guess can't do when it comes to bringing their teams back. So we have a couple of presenters from Forte Law. We have Jim Wu. Jim joined Forte just over a year ago after some time running his own employment law firm from his home in Burnaby, right across, not too far from where I'm based here, so just the other side of Metrotown from where our office is. So obviously he's a Burnaby boy. I went to Nelson Elementary and went to high school at Burnaby South. Before law school, Jim worked as an EI adjudicator, and he is available today to answer your questions about EI. On weekends, you'll find Jim and his long-haired German Shepherd, Hutchko, herding sheep apparently, so look out for that. We also have Caitlin Denny. Caitlin joined Forte about a year ago as well, and her background is in civil litigation and family law, but now practices solely in the areas of employment law and workplace human rights. She shares the firm's passion for helping both entrepreneurs and employees navigate complex legal issues, and is also an avid soccer player. So they join us today in the offices of Forte Employment Law Solutions. The way that we're going to structure this today for everybody's information, Jim and Caitlin are going to go through some key information in a Q&A format. So I'll be asking them some questions that we've already heard from our members and from other businesses that they're keen to learn more about. So I'll be feeding those questions to Jim and Caitlin at the start. At the end of it all, please, through the Q&A chat section on your screens, please ask any questions that come up or that haven't been raised. And if there is time at the end, then obviously we'll go through some additional questions. Just as a bit of a disclaimer, Jim and Caitlin are not here giving legal advice in this public forum, so please take this webinar as a general information, not specific legal advice, and if you want legal advice, I'm sure they can point you in the right direction for that as well. So let's start off, and I have a question for Jim to start off with. One of the biggest concerns right now when bringing people back to work is ensuring a safe workplace. So Jim, what can businesses do to comply with health and safety obligations to workers?
Workplace health and safety is always a top priority for all businesses. You have to ensure that whoever enters your business, whoever is actually inside your area of business, they're protected and they're safe. That has been a very long-lasting law. What COVID-19 has added is an additional layer of an obligation for business owners, and that is to have what's called a COVID-19 safety plan. Now, there are 6 steps involved, and if you are someone like me who can't even remember the 7 colors in a rainbow, what you do is you devise fancy and cliched acronyms to help you remember that. So the one I've developed for this is called WINDOW, and I've chosen the word window because, as cliche as it sounds, this is our window of opportunity not only to flatten the curve, but to stamp it out altogether. So what does window consist of? The first item is conducting a workplace risk assessment, and that's just going around your area of business, identifying any hazard that you think might actually contribute towards the spreading of the COVID-19. The second step involves implementing measures to reduce risk. And what that entails, it's different across every business. If you go to the WorkSafe BC website, they have a very useful chart where they have a hierarchy of measures for each sort of business. At the very basic level, if your business is able to minimize any sort of contact minimize any sort of physical contact with members of the public, that's at the base. And at the very apex of that pyramid is if your staff or if your business is a type where physical interactions are just inevitable, then you may want to consider personal protective equipment. The third step involves nailing down your policies. Policies are important because they are the fine print of how you would go about implementing your measures, and they're also a way for you to communicate with your staff and also get insight on how ways which you can implement these measures to the most practical suits of your business. The fourth step involves developing communication plans and training. So what this entails is having signages out in the door. You'll see a lot of businesses, for example, in our building, they have a warning outside saying if you possess any of these symptoms, please do not enter our building. I have seen other businesses where they have limit to only 4 patrons outside the store. Have signages very clearly outside the stores. That way it will alert members of the public to what they need to do. But they also provide your staff with some guidance on how to implement those measures. For example, if you're that store that says the maximum limit is 4 people outside the store, then you might need to devise some sort of crowd controlling training for your staff. The fifth step is be open to suggestions and changes, because there isn't any cookie cutter plan out there that will encompass all the foreseeable potential risks involved with COVID-19. You have to be amenable. This cannot be dictated by one person. You definitely need insight from both your staff as well as members of the public, and be able to be open to changes and regularly change your COVID-19 safety plan. And the last part is make sure you walk it through your staff, because your staff are the people who implement this. We're in this all together. It's very important that we're all on the same page. And just to summarize all the steps involved, there's what's important to have a COVID-19 plan. If there's one takeaway for everyone watching this, it is because WorkSafe BC can conduct an investigation at any time. And guess what? The first question will be, where is your COVID-19 safety plan? And when they ask that, you better have one prepared.
Thank you, Jim. Some useful information there. So another question, I'll direct this to you as well, Jim, is a lot of businesses are experiencing a situation where they have work available, but the employee doesn't want to come back. Can employees refuse to come back?
The answer is yes, employees can refuse to come back. However, the parameters, just like with all legal tests, is whether the grounds for refusal are reasonable. So to give you an example, pretend Caitlin and I have an assistant named Karen. We don't actually have an assistant named Karen, but let's say Karen's laid off. We ask Karen to return to work. Karen is mortified that she might contract COVID-19, and we find that she has well-suited grounds to be afraid. In that case, we have the obligation to work with Karen to find ways to help her gradually return to work, whether that means giving her a copy of our COVID-19 safety plan, getting her input as to, okay, Karen, well, here's our plan. What can we do to help you gradually return to work? And the employer cannot just give the employee a call saying there is work available for you, and the employee says, I'm not going to return to work, and the employer tells that employee, I don't care why you're not returning to work, you have to return to work. If you don't return to work, I'm going to consider you to be quitting. Don't do that. An employer must ask questions. They must work together with the employee. And again, it's all about how reasonable the refusal is. And the employer has to, at the very least, tell the employee what the ramifications are behind their refusal to return to work. So to return to our example, let's say if Caitlin and I have done everything we can, we sent Karen our COVID-19 safety plan, and then Karen tells us, I still don't feel very comfortable returning to work, even though it looks on the outset that everything is safe. Then we need to tell Karen, look, Karen, you have to return to work. We've done everything we can to help you get through this. If you are not returning to work, well, let me tell you what, you are refusing work. And if this continues, we need someone to work here. And if you're not going to work here, then we have no choice but to process your refusal to work as a resignation. You have to spell out the consequences to the employees so that they know exactly what occurs when they continue to refuse to work.
Okay, thank you. I'm sure there'll be some questions raised from some of the answers that you're giving here, and hopefully we'll have time to get to some of those at the end, because obviously there are lots of different scenarios that could occur in the example we've just been discussing. Caitlin, are there any risks associated with bringing certain workers back and not others? If it's a slow rebuild and you can't bring everybody back, can you choose, and how do you choose whoever you want?
Yeah, so you can't choose, whoever you want based off of certain criteria. So I guess my first point is that the government has introduced new job-protected leaves, and they've been added to the BC Employment Standards Act, and they remain in effect. And those leaves allow certain employees who meet the requirements to stay off work without risking their job. So these leaves can be found under Section 52 of the ESA and are available for employees who have been diagnosed with COVID and are following instructions of a medical health officer or the advice of a doctor or nurse, employees who are in quarantine or self-isolation and following, an order of the provincial health officer or under the Quarantine Act, employees who have been told by their employer not to come to work due to a concern about exposure to others. Those employees would be able to fall under these job-protected leaves. The fourth is probably the most common one, employees who need to provide care to their minor child or a dependent adult who is their child for reasons related to COVID-19. So that could be, school closures or daycare closures. So schools are reopening in September, so this may be less of a concern now, but things, as we know, change quickly. So yeah, people with parental responsibilities who can't find childcare would fall under this leave as well. And then the last qualification there are employees who are outside of BC and unable to return to work due to travel or border restrictions. So if employees can meet one of these requirements, they are entitled to a job protective leave. So these leaves are indefinite. There are no duration limits under the Employment Standards Act right now, and employees who fall under one of these provisions and who remain off work will be on an unpaid leave. Some of these employees will already have been on a temporary layoff. A lot of businesses have had to lay people off. If they're unable to come back to work because of one of these circumstances, then they would no longer be on a layoff, they would be on an unpaid leave. So their temporary layoff would still end, and then they would be on this leave. So if employees are refusing work for one of these reasons, businesses should tread carefully and make sure that they're not, falling off side of the Employment Standards Act.
Sorry, Caitlin, can I just ask one question on the previous slide?
Sure.
Where you were talking about the school, and obviously schools are due to reopen.
Mm-hmm.
There's been a lot of talk, maybe anecdotal, but some talk about some parents saying, well, schools may be reopening, but I don't think I'm comfortable sending my child back.
Mm-hmm.
How does that factor into this?
Yeah, that's a good question. So yeah, we haven't, I'm sure we'll be dealing with this as it comes up, and I expect the answer is going to be based on, the circumstances of that child. And, it's possible that, if a child is dealing with, an underlying health condition, or is immunocompromised, or someone in their family is immunocompromised, and there's, health concerns there, then yes, it's possible they would, I think, likely fall under this leave. If it's, a general fear of exposure that's not related to an underlying health condition, that may or may not fall under the leave. I think it will be circumstantial in that case. And I expect that we may see more commentary on that, either from the government, provincial government under the Employment Standards Act, or the federal government. So yeah, I hope that answers your question, but
yeah, thank you.
I expect it will be circumstantial. So that, I guess, leads, so offering return to working parents. So many, I guess, working parents will be concerned about this. It's important for businesses to continue to include working parents in return to work plans, and not assume that parents will not want to return. So I guess the assumption may be that most kids will be going back to school, but you should not assume that parents will be keeping their kids at home, and make sure that you're offering, that return to work the same way that you'd be offering someone who doesn't have children. If that becomes a factor and you're leaving them out of return to work plans, that can be discrimination. Which leads me to my next point on this, which is the Human Rights Code. So under Section 13 of the BC Human Rights Code, discrimination is prohibited in employment on the basis of certain protected characteristics. So there's 13 prohibited grounds, and those include, the basic ones: age, disability, family status, sex, political belief, and there's 13 there. And these characteristics cannot be taken into account when making decisions about who will be called back to work and in what capacity. So businesses can consider what skills are needed and what positions will add value. So you can make a business decision about who to bring back based on skill, knowledge, and the work that you need done. However, none of the protected personal characteristics can be taken into account. And if any part of the reason for the decision to not bring someone back is related to one of these grounds, that could open a door to a human rights complaint, even if it's not the main reason. If you have, 5 employees to bring back and they're all in their 30s and one person is 58, and you decide not to bring the 58-year-old back because they'll probably retire soon, that you may be opening a door there because it doesn't look good. So, you can make business decisions, but, tread carefully if personal characteristics could become part of that decision. And this often comes down to, the termination meeting, and employers should be careful about how they are terminating employees and how they explain the reasons behind that. And that may seem obvious, however, it can easily happen, even when people are well-meaning. So, approaching older workers about early retirement, for example, or asking pregnant employees to start a maternity leave early, so that they don't need to be called back to work. While that can be well-intentioned, it can make workers feel singled out, or sidelined because of a personal characteristic, and then that can open a door to claims. So I think if a worker, The other aspect of this is that if a worker does raise a human rights issue as impacting their ability to work, the most common one is a disability, for example, if someone's immunocompromised in some way, the employer must consider how they can accommodate those restrictions and limitations. So employers have a duty to accommodate, and that can include, different work hours, or performing other tasks that they don't normally do, and that duty to accommodate is, a two-way street there. It should be an open discussion about what's reasonable in the circumstances, but employers do have a duty to accommodate up to the point of undue hardship, which can be a high bar to meet. So, if a human rights issue or concern is raised, employers should, seek legal advice and tread carefully about making decisions about whether or not to bring those people back or to terminate them.
Okay, thank you, Caitlin. Another question I'll direct to you, if I may, which is
Sure.
there are still many restrictions on how businesses can operate, including physical distancing requirements and, of course, customer and worker safety. This could affect a worker's hours or their job duties. So what should businesses keep in mind when adapting to new business operations?
Yeah, so the new normal at work may look very different for certain businesses depending on the industry, and that can be, dramatically different operations or staffing requirements. So you should keep in mind that fundamental unilateral changes to a worker's position without their agreement can be constructive dismissal. So constructive dismissal means that the actions of the employer have effectively dismissed an employee from their job, and they can walk away as though fired and claim severance pay. So an example of that would be, a reduction in their hours or compensation by 20% or more. Employers can make minor changes from time to time to positions and hours and so forth, but fundamental changes that aren't agreed upon can lead to constructive dismissal claims. So we expect that, the courts will be requiring, employees and employers to be somewhat flexible, given that this pandemic is an unprecedented situation. So, everyone will have to adapt to some change. However, workers can refuse significant changes, claim constructive dismissal and demand severance. So that can be, a significant liability for a company. So to minimize, the risk of a constructive dismissal claim, it's important that, any significant changes to the business operations or staffing requirements are discussed with workers ahead of time, and if possible, agreed to in writing. So we've been assisting employers with return to work agreements, which employees sign before going back to work. And these agreements are good because they have, both parties on the same page about what changes are necessary for the business. And if there's an agreement in writing, that really reduces the risk of any constructive dismissal claims because they have agreed to those changes at that point. So that is something to keep in mind if businesses are foreseeing that change will be necessary, or if that they'll have to be recalling workers to slightly different positions than they otherwise would have, reduced hours, reduced compensation, different job duties than they had before. So something to keep in mind.
Okay, thank you. Talk about dismissal. There may be some workers that a business decides not to recall. So what liabilities should be considered before making this decision?
Yeah, so if you are not recalling an employee, then you are terminating their position. And when you terminate someone, you need to give them termination pay or severance pay, as we call that. So, and if employees are on a temporary layoff at that point, so they're on a layoff, and a layoff under COVID-19 can only be for 24 weeks. And after that 24-week period, it becomes permanent. So that's one thing to keep in mind. And I think Jim may be talking more about layoffs, but if you get to that 24-week period and it becomes permanent, an employee can claim to be terminated and seek severance pay as well. So that's the other way to get there. And so severance pay is determined by three things. So the Employment Standards Act, which is the minimum amounts that need to be provided, an employment contract, if there is one, and the common law. So the Employment Standards Act is based on length of service, and that's, 1 week for the first 3 to 12 months. After 1 year, it goes up to 2 weeks, 3 years, 3 weeks, 4 years, 4 weeks, all the way up to 8 weeks. It's capped. And that's everything that employee would otherwise earn if they were, sitting at their desk for those 8 weeks. So those are the bare minimums that you would need to provide on a termination. The next place we look is your employment contract, if you have one, because that can often limit severance pay. If there is no binding contract, an employee is entitled to common law severance, which is judge-made law. So that's judges looking at a worker's age, their length of service, their duties and responsibilities, so the nature of their job, and the availability of alternative employment. And using those factors, the judge determines how much reasonable notice a worker should receive, and that can be significant for long-term employees. So there's a soft cap at 24 months of pay, which is a huge financial liability for a company. If you have a 20-year employee, they could be close to the top end of that range, and that's quite a big difference from 8 weeks as well. So common law severance is important to keep in mind when deciding who to call back. So, that common law severance period is subject to the duty to mitigate. So employees have an obligation to go out and take reasonable steps to look for new employment to minimize their losses. However, they're, not required to take a demotion or a pay cut. They're expected to look for comparable employment. So depending on the industry, there may not be as much availability out there. And so, that can lead to significant severance payouts. So I guess, from a practical perspective, when deciding who to call back to work first, employers may want to sit down and just consider who are their long-term employees, who has employment contracts, and who has, a larger severance entitlement. And then you may want to bring back workers first who have, higher severance entitlements, and that will reduce your severance liability in the long run, especially if you're getting close to that 24-week deadline for the temporary layoff.
Yeah, okay, well, thank you very much for that. Jim, obviously this puts a lot of our businesses at a huge potential liability. Is there anything legally that businesses can do to protect themselves? For example, can they argue that the contract has been frustrated or put the employee in a temporary layoff?
Right, so on the advice I usually give employers when they're trying to contemplate a frustration argument is advancing a frustration argument can be very frustrating. And this can be seen by the actual wording of the frustration argument shown on the employment standards, which I've emphasized that in order for an employer to avoid any sort of severance obligations or termination liabilities, the employer has to prove that the employee was employed under an employment contract that is, and I emphasize, impossible to perform due to an unforeseen event. And I note that the latter part of that sentence mentions the Insolvency Act and the Bank Act. So that's already presumed that if the circumstances which has led to the business has resulted in that business experiencing severe economic hardship, that would not be grounds for a frustration argument. But the word that really captures the whole essence of how difficult it is to advance is the word impossible. And everything is going to be, the provincial government has already announced that they will not actually issue any sort of guidelines, any sort of a cookie cutter template to give sort of criteria as to who would actually qualify under this provision. They made it very clear that every argument for frustration will be seen on a case-by-case basis, which I believe does make sense. In terms of temporary layoffs, I want to discuss that a little bit. Like Caitlin mentioned, it's a maximum of 24 weeks and ending on August 30th, 2020. Now, employers, they can apply for a variance to extend the layoff beyond August 30th, 2020. And I believe the deadline that they have to make that application is August 25th, 2020. There is a specific link below where employers can get more information. However, the main catch is that for employers who are thinking of applying for an extension, they must have 50%, more than 50% of their affected employees on board to apply. The other tidbit I would want to give in terms of temporary layoffs is, you will recall that Caitlin mentioned the duty to mitigate, which is that if an employee, let's say we have an employee named Joshua is a long-term employee. His severance period would last 24 months, but Joshua is very diligent and he finds work, say in 2 months after he's terminated. Well, great for Joshua's previous employer, because that 24-month has now been reduced to 2 months only, because Joshua's effectively completely mitigated for the remaining 22. However, with a temporary layoff, you put the employee on the notice that you don't have to look for work, and here's why: because we are going to recall you at any time within those 24 weeks. And that's a humongous gamble that the employer is taking, because by doing that, and if you don't have any work available for, let's say Joshua was put on a temp layoff for 24 weeks, and at the end of it, the employer has no work available for Joshua, then as lawyers, the terms we use is those 24 weeks have been crystallized, meaning there's no way that the employer can wiggle out of it and say, well, you could have looked for work, because the argument is there was no expectation because Joshua was expecting to return to work. And then all of a sudden, you would now have what's a 24-month maximum liability, but also a 24-week minimum liability. So it is something that an employer should take into account. And sometimes it might just be the case where the employer just has to take the bullet and consider, just like Caitlin mentions, okay, we might as well cut our losses and we will actually have to terminate the employees. Let's do a risk assessment, get the services of an employment lawyer, seek sort of what the ranges are, because the 24th period that the courts give, that's a discretionary period that's always subject to the employee actually advancing their claims in court. That's not a mandatory minimum requirement. And ultimately what it comes down to is 90% of cases, they all settle. Therefore, if the employer is willing to give a reasonable offer to the employee, that might actually turn out to be the cheapest and most effective way to minimize their losses.
Thank you, Jim. And I think just one thing that on this applying for variance that you just touched on, and you mentioned the August 25th as being the date that you have to get it in. I suppose as well, in order to complete the form effectively and comprehensively, and to get the responses from all of your employees so that you know you've got more than 50%, you probably want to give yourself almost a week to go through that process.
Absolutely.
So I know this is something we've been posting on social media and in our newsletters and on the website. So just a heads up to businesses there that it may say August the 30th, but you've really got to start getting that process going. I would have thought by about 11 o'clock. You probably want to get that going for pretty soon. Thank you. We've got a question that's just come through here, and I would encourage those on the line to through the Q&A function to ask us some questions. And this question is in the area of a parental-based reason for not returning to work, and the person saying I'm not coming back because of parental responsibilities of some type. The questioner is saying I have to hire someone for the role. I can't just leave it open indefinitely. Especially when in their organization, you don't know how business sales are rebounding. So they need somebody in that role. How would you handle that?
Caitlin, you want to answer that?
Well, you definitely can hire someone to fill that role. You know, businesses have to move forward. You know, the tricky part is that this person is on leave, and that's a job protected leave. So they can't be terminated for the reason that they have parental responsibilities. You know, depending on the circumstances, like it depends how long they're going to be off as well, and when they're going to be able to be recalled to work. You know, if you know, I don't know, Jim, what are your thoughts on if there's a position available for them or not?
The position's available and it's premised on the, ultimately I mean, it's a balancing act, and ultimately what the key advice I always give employers is communication is key, and that's ultimately that diffuses, that's ultimately what separates from an employee understanding the situation versus an employee who's very confused, very upset, and then goes sees a lawyer. So if you are considering making certain changes within your organization, it is key for you to communicate those criteria to your employee.
Yeah, I think if you're hiring someone new to fill that position, I think you should communicate that to the employee. And yes, you're on a leave, but I will be hiring someone to fill your position for the time being. And, you know, depending on the circumstances, you know, that parent, that employee may be finding a different position that works better for their parental responsibilities at some point.
The only caveat is, if you are doing that, just be mindful that if the employee does return or insist on returning to work, that there is a position available for that employee to return to. It doesn't have to be exactly the same position, but it has to be one that's comparable. And by comparable, what they're really looking at is comparable rates of pay, comparable amounts of hours needed per week.
And a position that's, you know, within their skills and experience, and not something that they're not able to do.
Yeah. I've just noticed, and just we'll carry on this area of conversation, but just I've noticed a couple of folks on the line have raised their hand, and I would just encourage. I might be wrong here, but I don't think we can actually loop you into the conversation. I think you probably need to type in if you've raised your hands because you have a question. If I could ask you to type that into the Q&A box or the chat box, then that'll flash up on my screen that you've done that. So looking in here we are. So we have a question here. An employee has not returned to work for 5 months and has a doctor's note stating that the employee has anxiety due to COVID. The employer was advised to send a medical questionnaire to determine accommodations they would need to make. Where would the employer find this kind of questionnaire?
So my answer for that is it's very hard for an employer to find any sort of answer online, just because the set of circumstances that this employee isn't very specific. You will need to know what her situation is like, and then from there you need to, at the very least, be able to sit down with the employee, grasp sort of his or her conditions, and then from there fill out a medical form that actually specifically asks certain questions. It's pretty hard for, there is no generic template, and I do caution anyone who finds anything online that because it isn't drafted by legal counsel or by a lawyer, that there are a number of risks involved. By hiring a lawyer, the lawyer actually does look at your set of circumstances and situation, and they do have the expertise to draft this kind of a document. And if anything does go wrong with that, the document which you find online, there is no repercussion you can rely on, whereas for lawyers, they are all under professional obligations, and they have professional liability insurance which can cover these sorts of events.
Thank you, Jim. We've got another question here, and I guess this could work for either people who have been laid off and are being asked to come back to work, or even people who have been working from home during this period. If somebody is saying, you know, in either of those situations, that they'd like to continue to work from home, in this particular question, the employee has gone online and with 2 different doctors for doctor's notes, and he's basically essentially been signed off for several months. So in that example, what rights does the company have? But also, I guess, if people have been working through this but working from home, and some people might be thinking, well, this is where I'm comfortable, not just because it's a comfortable setting at home, but from a health and safety perspective, where does the company stand on that?
Well, I'll take this one, Jim, and then maybe add it to you if you have any follow-up. But so employers can require employees to come back to the office. You know, I guess the issue would be treading carefully if there is a disability or a medical reason why they can't do that. You know, I think, you know, to approach a situation like that, you may want to provide your COVID safety plan to your employee and suggest that they have their doctor review the COVID safety plan and then provide a note, you know, assessing whether or not this employee can work in the workplace given all the safety precautions that are in place. So I think that would be a step to take to determine whether or not there are, you know, a disability or a special circumstance that would prevent them from coming in. Otherwise, they can be required to return to the workplace. If they're refusing, that can look like a resignation. But again, you would tread carefully here, given the medical issues that have been raised. Jim, do you have any follow-up on that?
I agree. I totally agree. It goes back to what you said earlier, Caitlin. This is a classic example of the duty to accommodate. And like Caitlin mentioned, it's a dialogue between the employer and the employee. Just because this particular employee has medical notes, that doesn't necessarily give that employee a carte blanche to actually say, I insist on working at home. Now, if the doctors, we don't have any sort of information about what those notes say, and please do not tell me what they say, but let's say hypothetically that the note says that I recommend that this patient work at home. That is another consideration for the employer to take, and that will be something that the employer may need to make some sort of reasonable accommodation towards. But if the note simply says that the employee is sick and doesn't actually go so far as saying that the employee is, that I recommend this patient work at home, then you're correct, Caitlin. The employer can insist that the employee, once he is fit to return to work, to come to the office or to the actual place of work.
Thank you. I think that's all we have in terms of the questions that have come through. But I suppose to sort of wrap up, it sounds a lot of what you've been saying is clear and open communication is vital. I guess not just in these times, but in all times, but particularly now where we are in such an uncertain atmosphere. So clear and open communication. Get your plan in place, your safety plan for the office. And are there any other key takeaways that you'd like to leave the folks on the call?
I guess one would be just keeping in mind, if you're deciding who to bring back and who not to bring back, that there are certain protected leaves under the Employment Standards Act, and, you know, personal characteristics, protected grounds under the Human Rights Code. You may want to keep an eye open for any special circumstances, like parental responsibilities or disability that would, you know, open a door to a human rights complaint if you were to terminate that specific employee. So just be aware of those personal circumstances that could, you know, create bigger issues for you down the road.
And Jim, sorry, just before you, I don't know if you had anything to add, but we just had a question pop up, which is quite an interesting one, which is an organization that is planning to change employee working styles to remote or hybrid, but certainly a big change to how employers will work in the future. And I guess this is almost the reverse of what some of the questions we've been discussing already, where in this case they're looking to encourage people to work in a remote or hybrid fashion. Could that open them up for constructive dismissal?
Again, it ultimately depends on the test of constructive dismissal, whereby it has to be a material term of change. Now, let's say, for example, that I'm going to give you an answer which sort of has ranges to kind of pinpoint the best answer I can give in those circumstances. Let's say if the employee is required to actually be at the workplace because all of her supplies, all of her tools, all of the equipment which he uses are all over there. Then in that case, asking the employee to set up a shop at home and basically have all of their tools. She needs to reclaim all her tools and have everything set up in her home to work remotely. That might lean towards a constructive dismissal. Whereas if it's a position where it's clerical, your only equipment is just a computer, which you can take with you at all times, and the company is the one paying for the computer, and the company is also willing to reimburse you for all of your internet fees, all of the fees associated, and even willing to give you a stipend to compensate for any home utilities that you would now have to allocate towards your work, then that minimizes the likelihood that that would be a constructive dismissal. My takeaway for employers is we're all very tempted to go with these all or nothing remedies whereby, oh, there's frustration or there's a temporary layoff that absolves me of all liabilities. The thing employers need to keep in mind is, number one, that's very hard to advance, and number two, it's very hard, even harder for the employee to swallow when you tell an employee that's been there for a very long period that because of such a reason, even if it is a legally sound and valid reason, we're not going to pay you a cent of severance. That can very well trigger them to go see a lawyer because they are upset. So my takeaway is, if employers can, in this time, everyone's making compromises. So if the employer is taking the first step to make a compromise, it does go a very long ways in trying to promote settlement and resolving things amicably and minimizing any sort of lawsuits. Because as I always tell people, when you commence a lawsuit, the only people who make monies are the lawyers.
Yeah, well, I think we've probably heard that phrase before, Jim. I think, and I think it's very, I think it's very sage advice to say that through open and clear and honest communication, an awful lot can be achieved, and I think that's good advice. So thank you very much. I'd like to thank Caitlin and Jim for helping us with this webinar today. It is an important subject, especially, as I say, we start getting into the fall period where you're imagining more companies are looking to try to bring people back and get people back into the workforce. So a very important topic, and thank you very much for answering all the questions and providing such an informative guidelines and information for businesses to work with. So I'm going to kind of do some kind of virtual clap, and thank you very much for all of that. And on behalf of the Board of Trade and our participants today, thank you. And to those of you that did participate, thank you very much for joining us today. We hope you found it useful, and keep an eye out for any future events, because we're doing a few events a week at the present moment as we try to help businesses navigate their way through everything that we're going through. So thanks to participants, and thanks very much to our panelists, Caitlin and Jim. Thank you.
So thank you.